When I got my jury summons, I can't tell you what I was thinking. To say I was irritated would be to put it mildly.
And I was excited. And I thought, wow, I wanted to do it.
When I finally got the summons, there was a little bit of humor because I felt that, oh, here it is, they got me.
I thought, oh my goodness, I'm self-employed and I do pottery, and I thought it was going to interfere with my business.
Entré para adentro, abrí la carta, fue la primera que abrí que me acuerdo.
I went in, I opened that letter. It was the first one I opened, I remember that.
Entonces cuando ya leí de qué se trataba, dije, pues es bueno, está muy bien porque era la primera vez.
Then when I saw what it was about, I thought, well, that's good. That's really good because it was the first time.
When I got my jury summons, in all honesty, I was very disappointed.
I think it could be a scary thing when you first see that summons and you're not sure what to expect from it.
I knew it was my civic duty to serve, but I also thought, how will I ever find the time to be gone?
Congratulations and welcome to jury service in New Mexico. You are here because your name was drawn at random from one of several databases, including voter registration rolls. American citizens can show their patriotism in many ways: serving in the military, voting, and serving on a jury. As an American, you should understand that jury service is one of our most important rights, duties, and privileges. Yes, that's right. Jury service is a privilege. We are so fortunate to live in a country that values our opinions so much that it allows us to have a say in protecting the rights and the freedoms of our fellow citizens. This presentation is designed to give you a brief overview of what to expect as you begin your service. We want you to be as well informed and as comfortable as possible when you become part of the greatest judicial system in the world. The founders of our nation thought so highly of the jury system, they were willing to fight and, if necessary, to die to retain the right to jury trials for their new country. To understand why juries are such an important part of the American ideal, we must look back over 800 years to England. Here, through upheaval and trial and error, our jury system was born. In the early medieval times, criminal cases were commonly decided by different ordeals or trials, such as by fire or water, to see whether God condemned the accused person. Some of these trials were horrific. Defendants had to pluck stones out of boiling water or even molten lead. If you didn't get an infection from being burned, you were innocent. Or if you didn't drown after being weighted down by a rock or tossed in the water, you were clearly supported by divine intervention and judged to be without guilt. Otherwise, you would be put to death. Quite often, that was the result. Later, in 1215, when King John signed the Magna Carta, it provided that no freeman shall be taken or imprisoned except by the lawful judgment of his peers. This was the beginning of your right to a trial by a jury of your peers. In the 1600s, early juries were controlled by the king's magistrate, who told jurors how to vote. Every once in a while, a jury would refuse to find in the king's favor, and the jury would be punished. But the trial of William Penn in 1670 changed all that. He was on trial in London for holding an illegal prayer meeting in public. The magistrate told the jury to find him guilty, but the jury did not. Instead, they found him innocent of all charges. The jurors were fined and thrown into the hole at Newgate Prison when they didn't comply with the wishes of the angry magistrate. One of the jurors was told, "You shall be locked up without meat, drink, fire, and tobacco. You shall not think thus to abuse the court. We will have a verdict by the help of God, or you shall starve," said the judge. 10 weeks later, the jurors were freed by the king's top appeals judge, Lord Chief Justice Vaughan, who declared the jury had acted correctly on the evidence presented to them, saying, "A juryman swears to what he can infer and conclude from the testimony of such witnesses by the act and force of his understanding." This became the foundation for jury independence. American colonists looked to juries as a check to the king's power and a source of fairness. By the time of the American Revolution, though, the king had taken away many of their rights and freedoms, including most jury trials. Congress criticized King George III for depriving us, in many cases, of the benefit of trial by jury. The right to jury trial was the only guarantee contained in all 12 state constitutions that existed in 1776. When New Mexico became a state in 1912, the territory had already had decades of acceptance of the jury trial as a right given to U.S. citizens under the federal Constitution. 2 of the 10 sections of the Bill of Rights in the U.S. Constitution protect the right to a jury trial. Today, by appearing for jury service, you honor our freedom and become part of a long and noble tradition that helps define us as a free people. It means you are willing to protect others' right to a fair trial and to help decide important issues through your service as jurors. While the courtrooms you will see in New Mexico vary widely, there are many common aspects. First of all is the bench. That is the usually elevated seat occupied by the judge. In a trial, the judge is the impartial person in charge, and he or she decides if and when certain procedures can be used or what evidence can be presented to the jury. A judge has a role similar to a referee. He or she is not there to assist one side or the other, but to make sure the entire process is handled fairly. To either side of the judge will be clerks, sometimes court reporters, bailiffs, or other security personnel. The witness stand is generally nearby on one side or the other. The jury box will usually be located adjacent to the bench. There are tables in the courtroom for the attorneys and the parties they are representing. In civil cases, there will be a defendant and a plaintiff. In criminal cases, there will be a defendant and the state represented by the prosecutor. The seating in the back of the courtroom is for the public. Almost all courtroom proceedings are open to the public. New Mexico has 2 levels of trial courts: magistrate and metropolitan courts, and district courts. Metro and magistrate courts hear criminal matters called petty misdemeanors and misdemeanors. Drunk driving and domestic violence are some of the criminal offenses heard by these courts. In civil trials, the alleged damages cannot exceed limits set by the state legislature. These courts have 6-person juries with 1 or 2 alternate jurors. In district courts, the criminal charges heard can also include felonies. In civil trials at district court, the damages are generally not limited. District court usually has 12-person juries with 1 or 2 alternates. New Mexico is the first state in the country to allow non-English speaking persons to serve as jurors. If you do not speak or understand English, the court will provide an interpreter if possible. There will be no charge to you for this service. You are probably wondering how the jury is chosen. Before you came to court today, you filled out questionnaires. If you are called to a courtroom as a prospective juror, the attorneys will review your answers and will ask you some questions.
Good morning, everybody. My name is Michael Harrison, and I'm the attorney for the defendant. And I need to ask, does anyone here know me personally? Or does anyone here know the defendant personally? If you do, please raise your hand so we can identify you.
This part of the proceeding is called voir dire, or jury selection. This procedure is an opportunity for the judge and lawyers to ask you questions about your background, life experiences, and opinions so that they may select a fair and impartial jury panel. There are no right or wrong answers to the questions. All the judge and attorneys want from you is an honest response so they can select the panel that will be fair to both sides.
Your Honor, I have a scheduling conflict.
Jury selection is also your opportunity to tell the judge and the attorneys if you have a conflict in schedules, hardships, or biases which would prevent you from being fair to one party or another. Please remember that the purpose of jury selection is to pick a fair and impartial jury and is not intended to pry into personal or sensitive issues you do not want to discuss in front of other potential jurors. If this happens, you can let the judge know out of the hearing of your fellow jurors, either at the bench or after jury selection when all the other jurors have left the courtroom.
I was really surprised that I was selected. Because I am a pastor, it seemed like no one wanted me on the jury.
And of course, I think you always hope that you're going to be able to do the right thing and make the right decision.
I was interested in the process as sort of a civics lesson for me. I'd never been on a jury duty or even part of it, so it was interesting to see the process.
When I was on the jury, I was the foreperson, basically. I got to tell everybody what to do, and they had to listen to me.
But I also was a little apprehensive, thinking maybe I wouldn't understand enough about the law to do a good job.
It scared me to death.
La primera vez que me escogieron,
The first time that they selected me,
estaba poco nervioso.
I was a little nervous.
I wanted to experience it because I never had before. And it was quite an experience to sit through the whole thing.
I might as well just give it a chance to see what this is all about. You know, it's always like they say, first for everything.
When you serve as a juror on the first time, it's very informative in how the judicial system works.
As a juror, you may be assigned to a civil or criminal trial. In a criminal trial, the state has charged the defendant with a crime. The jury decides if the defendant is guilty or not guilty of those charges. For example, you might hear a case of alleged drunk driving or assault or sale of drugs. In a civil trial, a person believes he or she has been injured and has suffered a loss. A civil trial might deal with a contract, a car accident, or a land dispute. Whether civil or criminal, the jury's job does not change. The jury decides the facts based on the testimony and evidence. When deciding what happened, the jury applies the burden of proof defined by the judge. Everyone has heard the term beyond a reasonable doubt in criminal trials. But what is that? A reasonable doubt is a doubt based upon reason and common sense, the kind of doubt that would make a reasonable person hesitate to act in the graver and more important affairs of life. It is not proof beyond all possible doubt. In a civil trial, the burden of proof is different. Generally, the party must prove the claim by the greater weight of evidence, something referred to as a preponderance of evidence. The jury decides whether the testimony and evidence show that something is more likely true than not. In certain types of civil cases, the burden of proof could be a higher standard called clear and convincing evidence. Once it is decided which cases are going to trial, there is often a lot of activity that goes on in the courtroom without the jury present.
Your Honor, we move to strike this evidence.
While you are waiting, the judge is making rulings on preliminary motions to determine the issues that you, the jury, will decide. Trials, whether they are criminal or civil, are usually conducted in the same manner. The procedure begins with opening statements.
Ladies and gentlemen of the jury, the evidence will show that my client is innocent.
This is the opportunity for both sides to tell you what they think the evidence will show, although these statements are not evidence. After opening statements, the plaintiff in a civil case or prosecution in a criminal case presents its case by calling witnesses to testify and or to present exhibits or evidence.
Your Honor, we call Mrs. Eleanor Jones.
The plaintiff or prosecutor will ask its witnesses questions. This is called direct examination. When the plaintiff or prosecutor finishes asking questions of a witness, the defendant or defendant's attorney may ask the witness questions.
Now, referring back to what you said about the night in question.
This is called cross-examination. Sometimes after cross-examination, the party who called the witness may need to ask more questions. That is called redirect examination. If that occurs, the court may allow a re-cross-examination. After the plaintiff or prosecutor is finished with its case, it will rest. In a civil case, the defendant will then present his or her case by calling witnesses to testify and present evidence. Then the other side will have an opportunity for cross-examination.
Please tell us what happened on the night of April 13th.
Remember, in a criminal case, because the defendant is presumed innocent, he or she is not required to present witnesses and evidence, but may choose to do so. That is because the burden of proof is on the state to prove its case beyond a reasonable doubt. After you have heard all the evidence, the judge will instruct you on the law. It is your duty to follow that law, even if you do not agree with it.
Ladies and gentlemen of the jury, the first thing you will do when you begin deliberations is you will pick a jury foreperson, and then you will begin reviewing the evidence.
After jury instructions, the attorneys will present closing arguments. What is said in closing arguments is not evidence. It is simply the lawyer's opportunity to discuss the evidence and the law that applies in the case. So after you have heard all the evidence, been instructed by the judge on the law you must apply, and heard the closing arguments, you will return to the jury room to deliberate. After deliberations are complete, you will return to the courtroom.
Fue muy bonito.
And it was very beautiful.
If you do have a jury duty call, go for it.
This is what our country's founded on, and this is a great thing for everyone to be a part of and to experience for themselves.
I think it taught me a lot about a little bit more about our judicial system.
And it's not at all scary. This just makes you feel good to know that you've done your very best, pro or con, for the case.
It was definitely an eye-opener for me personally.
One day you might be on the other side, and hopefully you got 12 people that are willing to listen to the information or the testimony and come up with the right answer.
I was surprised that it was such a positive experience. I learned a lot as a result of sitting on the jury.
It's the way our country works. It's the way justice in the country is processed, and I left with a lot of respect for that process.
If you consider yourself a citizen of this country, it's an important duty. It ranks up there with voting.
We hope your experience in this New Mexico courthouse will be both pleasant and educational. We appreciate both your time and your willingness to contribute to the cause of justice for your state and your fellow citizens. Jury service is the cornerstone of the American judicial system. It is both your obligation and your civic privilege to be a juror. Thank you for serving.
Everybody that live in the United States and out of it, everybody should be a part of this.
I think it's probably the best, a part of the best system in the world, and I'm certainly proud to have been asked and called to serve.
If you're a United States citizen, it's your duty to be on a jury.
Yes, it is a good experience for young people.
When you see people just blatantly trying to get out of serving, it makes you realize how important it really is. If everybody did that, where would our court system be?